Oh man, that music makes me want to go back to sleep. It's a lazy Wednesday morning. Welcome back. Welcome back to Law and Legitimacy, everyone. Welcome back, Mike. Good to see you again. Tell me about life in North Carolina. I've missed you.
It is hot, boy. I think I woke up and walked outside Monday morning, and I actually posted this on X. I said it smells like 3-a-days out here, baby. So, the summer cometh, and my thoughts and prayers are with all of the young men out there that are about to die in the honor of football and in the American tradition.
Well, unfortunately, a certain number of them will. But nonetheless, it is almost time for football season, and I love football season. I can't wait for it to begin because I will be looking at the undefeated University of Michigan Wolverines face a far more difficult season this year. And if we go undefeated this year, the universe can end. I would know that God will have existed, and yada, yada, yada. I expect a far different season this year. Go
Well,
Blue.
your boys, J.J. McCarthy and it was Andrew Corum, Blake Corum, both have found great landing spots in the NFL. So,
Where did JJ land up? I wasn't paying attention.
J.J. McCarthy is in Minnesota with the Vikings.
Wow.
The heir to that throne. They traded away Kirk Cousins, and so they've got a veteran journeyman just sort of out front for now. And then Blake Corum, the star running back, found his way to the LA Rams and is working with Sean McVay and that young, energetic offense out there. So love seeing that.
I just wonder how long a guy at 5'9" can survive the pounding of the NFL at running back. I mean, I realize the guy is a machine and he works out more than any of three other human beings, but a body is what a body is. But let's go Blue, and let's look forward to the football season.
Amen.
So we missed Monday and Tuesday of this week. We'll miss Thursday, maybe Friday, because I'm on trial in a location in Connecticut that makes it impossible to podcast and get to court on time. And so we're sorry. But Mike and I were talking beforehand about jury selection. And I thought it was such an interesting discussion. Mike, if you want to continue it, I think our listeners might find it of interest.
So I asked you how the trial was going, and you proceeded to tell me that it's probably one of the weirdest that you have ever involved yourself with, which I thought was fascinating. But then you went on to say, just in terms of the cadence of the firm and everything that you've got going on, that you had entrusted jury selection in not one but two cases to the associates at your office, to which I could not keep myself from asking the question of, how do you divorce yourself from that decision-making process? In other words, we've talked so much. We had Jim Nugent on the show however long ago. It's been a couple of years now. I remember.
Yeah, time to have him back. Yeah.
I actually ran that podcast from my car on my iPhone, if you can believe that. I was driving through the country in the sticks of North Cac here. And I remember how in-depth and enriching that conversation about jury trials in general, and then the science of jury selection ultimately, especially within the context of how he approaches it with, I think, from the plaintiff's attorney's side. But I asked you, I said, when or how did you make the decision to sort of allow your associates, your underlings, your proteges to make those decisions? Because from my perspective, it's incredibly important, but I also have very little experience in that regard. I mean, really, in fact, just one experience in that regard.
I have spent thousands, and this is no exaggeration, of days of my life on my feet interviewing potential jurors. And how do I come up with that number? I've been practicing law 30 plus years. In Connecticut, we have something called individual sequestered voir dire, which is a long way of saying you get to question each potential juror outside the presence of the others. How did that happen? Our state constitution gives us a right to question jurors individually. State statute says you can do so outside the presence of others. And so we have lawyer-conducted voir dire in every case. And it is not uncommon when you need a jury of 12 and 4 or 2 alternates or whatever for it to take 2 weeks to pick a jury. It's not uncommon for jury selection to last longer than the trial itself. And so it's funny you should mention Jim Nugent and I. Jim and I just tried a murder case, and we picked the jury together. We each appeared each day, and we alternated in our selection of jurors. And we have different styles. Jim has what I call an affidavit face. He's one of these fundamentally trustworthy and good-looking guys. To stand next to him in court is to feel like the ugly duckling and the bad guy. But he has a way of opening people up. He has a way by asking open-ended questions of finding out what jurors really think. And of course, in voir dire, you don't get to talk about, or voir dire, depending on where you're listening in the United States or the world. You don't get a chance to ask about the particulars of the case, but you ask about themes that are likely to arise in your case. And you get a juror's reaction to them. And the thing that you learn in jury selection is that you're not looking for a right or a wrong answer. You're looking for an honest answer. And so what I will tell to a juror is, we're going to ask you some questions here that are frankly personal, and they're not intended to insult you or to pry, but we kind of want to pry just a little bit. But what we want to find out is, after we've talked to you about the case, do you feel comfortable sitting on the case? And many jurors will tell you they do or don't. And so, when you're picking your own jury, you have a sense of who the people are on the jury. You get a sense of their personalities. You get a sense of their strengths and weaknesses rather. When someone else picks that jury, you don't, and you rely on those notes. And so, are you disadvantaged? I think many people would say you are, and that you should and must pick your own jury. That would be, I suppose, Jerry Spence's theory. But there is a theory of jury selection that makes jury selection about the lawyer, and or about indoctrinating jurors to a theory of the case. And so, in the Spence method, by telling your own story, by being open about yourself, you encourage jurors to be open with you, and you encourage them to build a relationship with you such that you become more trustworthy, and perhaps they'll trust you in the margins at a close case. In terms of the indoctrination view, I don't know many lawyers who've tried cases for more than a decade that really try to indoctrinate anymore. I mean, I know books have been written on jury selection. I know that there are jury consultants who charge an enormous amount of money. I'm hard pressed to see the value in that. A well-conducted voir dire is not going to be an indoctrination session if you've got a judge who's paying attention. You're not going to be able to get up and say, do you believe that widows abused by drunken men should get all the money in the world to compensate them for their harm? That may be what you want. And it may be that you can find an artful way of saying that. But a judge is going to assure, in the name of a fair trial, that really the task of jury selection remains what it's supposed to be. Can you find jurors that are fair and impartial and can set aside whatever biases they have, whatever they know about the case, to decide the case based on the facts and law as they see it in the courtroom? That is jury selection. Now, in my office, we have right now 3 associates. I've had as many as 5. And their job is to help me work up the case. I never go to trial alone. I always have a second chair. This is a person who's worked up the file, knows where everything is. My job is to master the strategy of the case and to master the tactics, to figure out how to get us to not guilty or to the best possible verdict that we can. I will let associates pick juries for a couple of reasons. First, I can't be everywhere at once. So right now, I'm on a busy run. I tried a murder case, and during the murder case, a jury was picked for me in a case involving violation of a criminal protective order, involving a neighborhood dispute where people were shining bright lights into one another's homes. I've never had a case like that before. And it would figure it's on the Gold Coast of Connecticut, where there's a lot of money near New York City, and tempers about such things run high. So I had a young associate pick that jury for me, and he's trying the case with me. As that case began Monday, 2 other associates of mine were in another city picking a case in a college consent a rape case, a case that we've done many before here. And the associates that are in on the case have experience in that case. They know that kind of case. They know what kind of juror we're looking for. They know the case. They know the law. And so I trust their instincts to find me people who will be fair and impartial. Now, it's a little bit of a challenge, to walk in on the first day of jury trial when the jurors haven't met me. And so, there will be those who say that places your client at a tactical disadvantage because the clients don't know you to trust you. I'm cocky enough to believe that my courtroom performance is as good or better than anyone else's that I'm aware of, and that within a short order, that will be taken care of. I remember a case once where we got the case thrown out because of the mishandling of evidence in the middle of the trial, and there was a group of jurors eating at a sidewalk cafe as I left the courtroom, and they said, Norm, come on over. And so I did, and I said, okay, I gotta ask, did my hair put you off? Is it too long? When you first started talking, we thought, man, who is this hippie? But we forgot all about it, and within about 5 minutes, once we started listening to what you had to say. So I'm confident enough to think that I can overcome that disadvantage if it is a disadvantage. I know, Mike, in your case, I think you picked your first jury the other day, and you liked the experience.
I loved it. Yeah. So we talked about the what's up, Blue Raptor, bro? Hey, man. Anyway, yeah, we talked about the jury trial that I had in federal district court here in the Middle District back in May, and it was a very, very fast trial. And skip to the end, we had a jury verdict that came back in our favor within 42 minutes of the jury being sent to deliberate. But as part of the process at the beginning of that, right there at the beginning of every trial, you're picking the jury. And I told you, Norm, that I was really compelled by the lead counsel, my co-counsel's trust in me to lob helpful analysis of what I was seeing as the judge was conducting voir dire, right, from the bench, and then to also use our peremptory strikes sparingly. There's just an entire gamesmanship approach that I think I really appreciated that I never knew existed until really in that moment. And I think intuitively, I tend to excel in interpersonal dynamics.
I think that's true.
I'm good with people. I read body language well, and I also I think understand from especially from the civil context um, how to I guess there is some element of indoctrination, but it's issue based, I think, Norm. Again, this is I'm speaking purely from very limited my sample size of one, right? But my sample size is important to the extent it involved the basic elements of a legal contract under the law, right? Offer, acceptance, consideration, mutual assent. And indoctrinating the jury was the same as proving the elements of the case,
Mhm.
right? And that was what made it somewhat beautiful and somewhat efficient, but also I don't think easy is the wrong word, but at the end of it is like, how was it that straightforward, right? I mean,
How long did the jury selection process take there?
I would say I'd have to check my notes, but I think it probably took about an hour and a half, 2 hours maybe to pick the 12.
See, that's the difference between state and federal jury selection, because in Connecticut, it would take an hour and a half to go through 2 jurors, and you do them one at a time, and if you pick 3 or 4 jurors in a day, that's a good day. If you pick 5 jurors in a day, that's a shocking day. If you pick none, that's a bad day of fishing. If you pick 1, well, what'd you expect? And so, it's a long, long, long process. I've debated endlessly whether there's a difference between the 2 processes. So
So I would submit to you that I know that there's an economy of norm, right? You can only be in one place at one time. However, I will say that a key part of that experience was um, having the lead counsel there to engage with me on almost a one-to-one basis during that jury selection. So if I am sort of advocating for your associates, especially working under your mentorship, and obviously you're paying them, it's not like they're working for free. But I would say that any opportunity you have to just be there for any part of it to talk to them about the decisions that they're thinking about making is really meaningful. So I offer you
yeah,
that as a young
all
person.
right. Well, I'll hear that. I don't normally send people out to pick a jury who's never done one before without anybody.
For sure
You know,
not.
there's a collegial aspect to it, and it is called a law practice after all, and we all practice to make it perfect. But anyhow, hey, so I uh, I, I sent you a copy last week of the Victor Bolden law review piece because I just loved it, and and as life would turn out, you didn't, and that's fine. Let me tell you why I loved it, and then I'd like to hear your sense of the shortcomings. I've known Victor Bolden. Victor Bolden is a federal judge sitting on the United States District Court for the District of Connecticut. He's been on the bench, I want to say 10, 12 years, Harvard law graduate. Beforehand, he worked for the NAACP Legal Defense Fund and then briefly was corporation counsel for the city of New Haven. He and I once had a fascinating go around. I was representing um, a group of protesters on the New Haven Green incident to the Occupy movement in, I think, 2008 and 9. They formed a tent encampment on the city green. I think they formed it in October. Everybody expected it to disappear right away. It still existed come April, and it had become, in effect, an independent little city within the city with its own social problems and its own criminal problems. One lawyer, I can't remember his name, represented people in their interactions with one another. I represented Occupy movement on the green and its interactions with the city. And the city wanted it removed, largely because Yale's commencement was coming and the green is across from Yale. We had argument in front of a judge on whether the First Amendment right to express and associate and protest and petition pertained to a tent city. It did, however, the city was able to persuade the court that there were reasonable time, place, and manner restrictions, and the thing had to go. We took an appeal to the United States Court of Appeals for the Second Circuit because bulldozers were authorized to start taking the city down at noon on a certain day. We went to argue. We were tensely waiting for a decision. It got to be noon. I called Victor. I said, I don't have a decision yet. And you could almost hear the bulldozers starting. 3 minutes later, we got a stay for a brief period while the court considered it. I called Victor and he panicked and everybody stood down. In the end, the city was removed. He became a federal judge, and he's rumored from time to time to be on his way up to the Second Circuit Court of Appeals. It hasn't happened yet. But in this month's Connecticut Law Journal, from the University of Connecticut, he wrote a feature, Proof, the Rule of Law's Most Essential.
If I may. So Victor Bolden, just so I'm getting this correct, I remember walking around the city with you, Norm, and you were telling me this story about the Occupy movement, this legal issue with the city. In fact, one of the more compelling parts of that for Cam, because my law partner Cam was with us, was just thinking in the abstract about land charters from the crown,
Yeah.
and thinking through title searches and the chain of title and the conveyance of real property from hundreds and hundreds and hundreds of years ago. But this issue kind of bore on that there was an issue of who actually had legal authority to exert dominion over the piece of property that was causing, I guess, the upcoming graduation some heartache, right?
Well, it's an amazing story. The New Haven Green, which is, I think about that 16 square acre area. Again, don't hold me to the numbers, but it's relatively large. Is one of the few untitled pieces of property in the United States. It was initially conveyed to settlers by Indians. And the settlers distributed portions of the land to Christian settlers, and the city is divided in ways that reflect that division. And when they granted land to a settler, they granted that settler title. So you could have title to X number of acres in the 9th Square, which is a region in New Haven. But as to the green itself, no title ever conveyed to the green. And so it's owned by something called oh, doggone it. It's a 5-person board, the proprietors of the New Haven Green. And these folks reach back to colonial times. And at the time of the Occupy Challenge, the 5 members included the wife of Vito Calabrese, dean of the Yale Law School. Her family was one of the original settlers. Janet Von Arterton, a federal judge, a bank president. I think Drew Days, former Solicitor General and professor at Yale. And I can't remember the 5th. They own the Green, even though they own it without title. And they have a contractual relationship with the city of New Haven that permits New Haven to police it. And so our position was there was no rightful owner to dispossess the people from the Green. And this was the issue that brought the case to the Second Circuit. In the end, the police power of the extant powers, the city and the proprietors, prevailed, and these folks were asked to leave the Green. But it was one of the most amazing pieces of legal research I ever did. I found myself in the Yale Law Library, looking to see what I could learn about the New Haven Green. And I found an old study commissioned in the 1970s by a very prominent property professor who laid out the history of the Green. The proprietors were recognized by the state legislature, I believe, in the 18th century as having dominion and control over the property. But while they had dominion and control over it, they didn't have title. And so, to my mind, the New Haven Green may be one of the few untitled pieces of property in the United States. It is managed by a non-proprietary board that is that self-generates. It appoints its own replacement and is recognized by the state legislature. But realistically, I don't know what it is within the context of American law.
And a particularly vulnerable position to be in if you're not actually, if you don't have that original conveyance, right? I mean, we're talking about grants of land from the crown, right? And
well, actually, this wasn't from the crown. This was from the Indians. So these folks came to these were dissenters from Massachusetts Bay Colony who didn't quite like the way things were working out there, and so they came down into New Haven and they got the land from some Indians, and that's the way it is. Do locals still have the right to graze animals on the Green? No, because as it turns out, municipal ordinances governed the Green as though it were municipal property. I do not believe, Janet, that it's taxed. Connecticut has a very unusual system. We have no county government here. While we have counties on the map, we have 169 independent municipalities, each able to generate their own tax code. New Haven, given the number of universities and research institutions that are located here, has a very small tax base. And the result is it's one of the poorest cities in the United States. Its rate of infant mortality rivals that of certain third world countries. But that's enough on New Haven.
I digress.
But I digress. And here we are on Friday, still waiting to talk about this. So proof, the rule of law's most fundamental or most essential element. I read this essay. I couldn't put it down. And I guess the reason I couldn't put it down is because I've tried cases in front of Balden. I've tried cases against Balden. I've known him forever, and I have enormous respect for the institution of the court and for the rules of evidence. And I thought that in 30-some pages, Balden did a tour de force, talking about the importance of the concept of proof as a centralizing aspect of the American court system. A party can make an allegation, it can advance a theory of an event that can have legal consequences, but then it either goes into a criminal or a civil court where where proof is required, where a certain quantity of proof is required, whether it's proof beyond a reasonable doubt, proof to a preponderance of the evidence, and then a certain quality of evidence is necessary. In other words, you have to lay a foundation for a document or an item to show that it is what it says it is. You have to show that it's relevant. You have to show that it's reliable. And these theories of proof get embedded in various legal theories and judicial philosophies to make a unique American system of law where the courts are open to all to prove their case by standards that are recognized in the community. And, Mike, call me naive, but it really brought tears to my eyes. It brought tears to my eyes because I sometimes think we live in a world of disintegrating standards where anything is true just because someone says it is, or they can get enough people behind them online to assert the truth of an assertion. And we end up with conspiracy theories portrayed as proven facts when they're not really proven facts. They're just adopted by many without proof. And so I loved Balden's reliance on William Butler Yeats' words from The Second Coming. Turning and turning in the widening gyre, the falcon cannot hear the falconer. Things fall apart, the center cannot hold. Mere anarchy is loosed upon the world. The blood-dimmed tide is loosed in everywhere. The ceremony of innocence is drowned. The best lack all conviction, while the worst are full of passionate intensity. I don't know, Mike. I liked the essay a lot. I recommended it to my wife, who's a non-lawyer and who sometimes listens to my legal ramblings with a sense of, oh my gosh, here we go again, nerd speak. But I would, those of you who are non-lawyers and you want to understand a little bit about the internal architecture of how the courts work and about the importance of proof of facts in a piece of litigation, I can't commend the essay enough.
Yeah, I think that it's valuable for that, if for nothing else. And that's not to, I'm not trying to be, gratuitous with criticism here. I do think that what you just said is probably the most important thing that you and I could say to an audience of mostly non-lawyers, is that this piece does a fantastic job of talking about the sort of the quantity and quality of evidence in a courtroom as it relates to the issue of proof, right? And reaching the burden of proof in a court of law. So from that perspective, I totally agree. I think,
but you found some darkness in the footnotes. Tell us about that.
It wasn't necessarily darkness in the footnotes. I think that what struck me, but for sure, I'm because I'm that way.
You're not that way. You've got a critical intelligence, and that's the thing we love most about you, or that I love most about you.
So on the first page of the article, and I want to make sure that we don't get bogged down in this, because I do think that there's something more important about my criticism of this piece. But the introduction starts this way. It says, the last few years have been rather tumultuous in the midst of a global pandemic, which has resulted in more than 100 million cases of COVID in the United States and over 1 million deaths. This nation also has literally played witness to the death of George Floyd and an attack on the United States Capitol on January 6th. The nation has also experienced landmark rulings from the United States Supreme Court on the challenging issues of guns, abortion, and race. All of this occurred in less than half a decade. Two of these events, the death of George Floyd and the Supreme Court's decision in Dobbs, have tested the American public's faith in the rule of law. The footnotes are important because there's 5 by that point. And when you go to the footnotes and you actually try to click on some of the stuff, I think that I was struck by several things, right? Is that, in an article that is principally about this notion of proof, right? And proof is the essential element to the rule of law. I think principally this laid the foundation, perhaps a foreshadowing norm that colored the rest of the way that I read this. And the way that I read this is I was expecting Victor to transcend the problem that he was identifying. I personally felt as though he was unable to transcend that issue of fact versus fiction or personal truths in an era of very dynamic interpersonal connection via social media and online, being surreally online, we'll call it. And proof positive of that were the sort of flippant use of articles that I was able to trace back in the Wayback Machine or in the archive machine, that didn't necessarily, I think, prove the point that I thought he was trying to prove or substantiate the point he was trying to make, but principally on the issue of confirmation bias, which he spends a little bit of time talking about, the concept of confirmation bias. The footnote that he linked to was talking about vaccine hesitancy. And again, if we're talking about, someone that is writing about a concept so broad, it seemed to do a great job of alienating people for the perspective it adopted on what the truth of our current reality is. And from that perspective, I thought that it was limited, um, by 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 automatic application of, because even the language that he used around talking about the internet and sort of the how frequently people are able to make contact and stuff like that, it just seemed somewhat dated. And I'm not trying to be disrespectful. I think that the proposition that was advanced in the title and in that first introductory paragraph, or the blurb at the very beginning, not the introductory paragraph, gave me some expectation that this was going to be perhaps even more intellectually challenging
Yeah,
of a
yeah, yeah.
journey, and I didn't get that from it. And
No, there's a
he
certain woke disappointment to it because,
it
he does adopt a sort of left of center
in a manner of
version of what
speaking, I
has
feel
been
like,
proven.
yeah, I feel like that undermined, and that is palpable when you're reading this and if you're doing any of the citation checks, but principally the way that he just kind of slams you with what have become very, like, partisan talking points in a way. And I understand I'm guilty of it, you're guilty of it, whatever it is, but in something that I think could have done without all of that. I
So,
agree with.
you're right. So go down, scroll down just a bit, please, in the article.
Where do you want me to
Because
be?
I'll tell you when to stop. I'll tell you when to stop. When he gets there, okay, I mean, when he gets to stop right there. Go up, back up.
Yep.
When he gets into the discussion, his prelude is, well, vaccine this, that, and these are issues that got litigated one way or another in various courts. George Floyd still remains a topic to be litigated. What actually happened there, and what the meaning of it all was. And these are political cases, and I wish that Balden had begun with just the straight jurisprudence, because this is where the article really begins, section 1. Perhaps without fully realizing it or appreciating it, the linchpin of American law is proof. Our legal system is organized around principles of proof. Two basic principles, in fact: admissibility and sufficiency, or put another way, quality and quantity. From this point on in the article, I viewed it as sheer genius. And in what I meant by that is, I'm a busy trial lawyer. Things have heated up all of a sudden after a pandemic lapse where we were kind of free to get lollygag and have fun. Now the courts are jamming trials down trial lawyers' throats, and we run from one to the other. And sometimes it's difficult to remember what's actually at stake at a trial, what the fundamentals are. And I think that Bolden's article on proof and his recitation and citation of, like, Rule 900 in the Federal Rules of Evidence, which has to do with authenticity, Rule 404, which has to do with propensity evidence and exceptions to it, Rule 403, the notion that something can be more prejudicial than probative. This is the bread and butter of trial law. And so for those of you who want to get a snapshot into what makes a trial work, skip the prelude, because we know what doesn't work in our politics. It's all this partisan chatter that we try to avoid here, and we engage in from time to time, and try to do so civilly. But in terms of having an American legal institution that works, section 1, I think, is a great place to begin, and I commend it to all of you. So.
True. One thing that he did, and I'll see if I can scroll to it fairly quickly. He made a historical reference to the list of grievances that the framers
Oh,
and
yeah, yeah.
founders put pen to paper about before the first draft of the Articles of Confederation and what became the Constitution. And basically signaling the conditions for revolution, which you and I have talked about before. But I found that to be a really high point in this. I know I'm scrolling. I think maybe
Here
this
we are.
is
Yeah.
it right here. So this is the language from.
Right from the Declaration of Independence.
Yeah, I thought this was really interesting. And again, just to contextualize, this article is about proof, right? And ultimately he gets into talking about the theory of originalism, the theory of textualism, and different manners or modes by which lawyers and judges can adopt a perspective on how to get at proof, right? Substantiating both quality and quantity of evidence or information. And I thought this was really, as sort of just a historical reference point, amazing to me. This is what the founders said, in the Constitution actually put in writing to justify as their proof that there needed to be a disembodiment of the colonies and United States, America as it were, what became the United States of America, needed to distance itself from the crown, needed to break away from the crown. And the he here is obviously Norm talking about the king, right? The crown. He has refused to pass other laws for the accommodation of large districts of people unless those people would relinquish the right of representation in the legislature. There were a few toward the end that I thought were really interesting because I think we have been talking recently about, whether we would even recognize the conditions for revolution as the founders of the framers would have, I guess, provided or anticipated by way of the Declaration of Independence. But here are a few. I just want to read them verbatim. He has effected to render the military independent of and superior to the civil power. He has combined with others to subject us to a jurisdiction foreign to our Constitution and unacknowledged by our laws, giving his assent to their acts of pretended legislation. I'm thinking now about the World Health Organization, the World Economic Forum, things that we talked about in previous discussions, Norm, that have made their way into state law as advanced by public interest groups and stuff like that, for cutting off trade with all parts of the world. I'm thinking about Bitcoin and the development of digital assets and cryptocurrency, right? In the ongoing battle with the SEC for imposing taxes on us without our consent. I'm thinking principally about the hundreds of billions of dollars that are being funded into other parts of the world for war, right? That we as a public don't necessarily know a keen interest about, for depriving us in many cases of the benefits of trial by jury, for transporting us beyond seas to be trialed for pretended offenses. These are all. It's amazing how much staying power some of these things have, and trying to make sure that we don't get lost in perhaps the difference in the way that gentlemen spoke back in the late 1700s versus now. But it doesn't appear as though it's far too different than what we're looking at right now is sort of a populist sentiment for as an anchor or fuel for the drive or the polarity that we experience on a day-to-day basis, Norm. That's stuff that I think you personally are reacting against and trying to make a push for the center. This list to me was interesting because on one hand, he was using MLK to talk about the proper way to protest an unjust law, right? Civil disobedience and stuff like that. But then he was also using MLK to quote about, riots or violence being the language of the unheard in respect to the George Floyd stuff. And that's where I thought that this all failed, right? That there were these moments of obvious disconnect between the point being made and then sort of, I guess, pushing aside more topical events that are obviously not provable in the court of public opinion or known to us all. I mean, we look at the summer of 2020, we still have serious reservations about what happened during 2020 in American cities and the lack of justice or proportional justice that came in its wake, right? But then the use of these very, very forceful terms around what happened January 6, 21. And I'm thinking of you, the guy that was actually there talking about proof of seditious conspiracy as it related to your client, Joe Biggs, on January 6th. And what was the government's proof in that instance and how that was so different from the historical reference of proof, right?
Well, so the government did take an unusual take in the January 6th case involving the Proud Boys and talked about an implicit conspiracy that could have been proved at the moment independent of a plan. And of course, my view is that's not sedition at all, and we will take that up on appeal. I've been reading a fascinating book. I always try, once I find myself comfortable in a different field, I start to try to read books outside of it because I wonder what I'm missing. And so I recommend to you a book, Ryan Riley's Sedition Hunters. how January 6th broke the justice system. I'm nearly done with it now. And one of the things that inspired me to read it is my experience with January 6 defendants and my experience in January 6 courtrooms and following the cases and the literature that's emerged, and my preoccupation with what's going to happen in the 2024 elections. I think I saw in the New York Times the other day that President Trump daily reminds people that the elections will likely be stolen, will likely be illegitimate. And we have a chorus of people who believe that the country should be taken back, if necessary, by force, by revolutionary force. And a lot of those people came forward on January 6th, believing in the mission of John Locke and popular sovereignty and their right to resist and take their government back. And now their government has locked them up. At sentencing, many of these people now try to walk back the sentiments that they existed, saying they don't know why they believed them. They feel embarrassed. They feel this. They feel that. They feel everything else. But very few of them come forward to say, I was acting in the name of the people to reclaim a government that has been stolen, because they've not been able to make a case about who stole it from whom and for what purpose. And so I remain concerned about the rhetoric that Locke has inspired. And what I liked about the Balden piece was that this rhetoric needs to be tested by standards of relevance, by standards of admissible evidence, by standards of reliable evidence. And I liked it as a counterweight to conspiracy theorizing. I hear what you're saying about its weaknesses at the beginning and the end, Mike, but I'm on a mission to provoke a more serious discussion about the law, a more serious discussion about revolution and the right to revolt, and a more serious discussion about civility.
I think that this is an unfinished piece.
It might be.
And I believe that if he, in his position, he has access to younger attorneys, the same way that you have access to me via this show. And we've talked about TikTok and we've talked about social media, the interpersonal dynamics that exist online. I think a huge void in my mind is the ability to substantiate this piece about proof in a way that acknowledges fully the internet. And I'm not saying I know how to do it, but I am saying that there is that is what I was hoping to get more of.
I hear you. And he may not be in a position to do that. Although I've got a challenge for you. Write him a letter.
I will.
And issue the challenge, and tell him I said hello and I commended the piece.
If you can ensure that he'll read it, I will certainly write. I'll spend the time and write the letter.
No, he will. Victor Balden is one of the good guys. When you're in his courtroom, you will be heard. You may not like what you get as an answer, but you will be heard. Hey, folks, that pretty well wraps it up for our Wednesday and maybe only edition of Law and Legitimacy this week. Are you open to trying Friday, Mike, if I get a verdict tomorrow?
Of course. Okay. And I expect
people posted
to Laid Back Law as well. So even if we're unable to go Friday, I think I'll push on Eric to make sure that we can both be there on Friday.
Cool. Sounds fun. Thanks for listening, folks. And, I noticed on Twitter that at least one young woman is so offended by my recent change of course that she's left Twitter. So to her and she's left the stream. So to her and others, I give my customary goodbye. AMF yo-yos, we'll see you all soon.
AMF yo-yo Jules says, ever thought about extending the show to 1 hour? I mean, we flirt with it every day because we basically go 45 minutes. But no, I think we have got to build some value. So I think I want to dust off the locals page. I think that what this ultimately comes down to, Jules, as you probably know, is the fact that Norm and I do this and it's bootstrapped. So the time that we spend with each other and with you is necessarily to the expense of things that do actually pay us. And I say that without any sort of condescension or anything else. It's just very difficult. I've got, I'm a dad and I have a couple of businesses. This is a coveted time with Norm. If I think the key to answering that question is figuring out if we are able to actually justify it in a more practical way and extend the show. Because I do think that there's a lot more content that could flow from what Norm and I do day to day. I think
we would love to spend more time on it, but it's a matter of economics. I've got a law firm to support. I understand that there are law podcasters who generate tens of thousands, if not hundreds of thousands of dollars of income off of what they do. I'm not sure that they produce better value than we do, but they market more efficiently, and we just don't have the ability and time.
That's correct. So maybe as an invitation, Jules, I did some LinkedIn searching on you. You're an impressive guy in your own right. You know your way around the internet. So if you've got anything to offer over, send us an email. pattispodcast@gmail.com. Let's see. So just to be clear for everybody, if you're here, you should be subscribed. If you're here, you should have liked the video. And if you're here, you will hear now that we will not be here tomorrow, Thursday, and we are tentative for Friday. Is that fair, Norm?
Yeah, I think we're likely to be Friday because evidence closed yesterday. We'll give closing statements, and the jury will get the case. It was a 2-day case. Will it take them all afternoon to decide it? I don't know. We'll find out. So we could have a verdict Thursday, in which case we're back on Friday. If not, we'll see you next Monday.
Indeed. You can find us over on Locals as well. I'll start getting back to doing more of the notifications, the big posts over there. So if you're looking for a central hub for when we will not be live and stuff like that, I'll also post the Victor Balden article in there as well.
These, I guess, are referring to our colleagues, too, but they are all fat or on Coke. Well, my doctor tells me I need to lose some weight, and I do like Diet Coke. So I'm part almost of the club.
Not even 9 a.m., Norm. All right. AMF Yo-Yo, thank you, everybody, for being here. We will probably see you Friday. See you, Norm.
Ciao.